involve Myanmar's responsibility under an alleged breach of the Provisional Measures Order handed down by the court on the 23rd of January 2020. Now, this may sound like a bit of a long list, for indeed Gambia is in fact mentioning no fewer than 7 additional ancillary or subsidiary causes for responsibility over and beyond the commission of genocide. I will cover each of these in turn. But to avoid repetitions, let me give you a few cross-cutting comments related to the link between the main responsibility for committing a genocide and the forms of responsibility provided for under Articles 1 and 3 of the Convention. Mr. President, the parties agree that the forms of criminal conduct outlined in paragraphs B through E to Article 3 play a subsidiary role compared to the main responsibility for committing genocide. The Gambia calls them a range of acts ancillary to genocide. And as the court stated in the genocide in Bosnia case, once it has concluded that there is genocide attributable to a state and therefore that the responsibility of the state is incurred under Article 3A, it refrains from determining whether responsibility is incurred under any of the other acts of Article 3. And let me quote your judgment in the Bosnia case. If, and to the extent that consideration of the first issue were to lead to the conclusion that some acts of genocide are attributable to the respondent, it would be unnecessary to determine whether it may also have incurred responsibility under Articles 3, paragraphs B to E of the Convention for the same acts. Even though it is theoretically possible for the same act to result in the attribution to a state of acts of genocide, contemplated by Article 3, para A, conspiracy to commit genocide and direct and public incitement to commit genocide, there would be little point where the requirements for attribution are fulfilled under A in making a judicial finding that they are also satisfied under B and C, since responsibility under A absorbs that under the other two." End quote. In this case, and regardless of the fact that no genocide has been committed, Gambia is requesting the court accumulate the counts of responsibility and to rule on the ancillary causes for responsibility for the reason that, and I quote, "they are worthy of distinct findings." Why so? Because the Gambia says so. Regardless, the parties have radically diverging views on the conditions under which these ancillary or associate causes of responsibility can be incurred. By making a misreading of the paragraph of the 2007 judgment that was up on the screen, the Gambia considers that since each of these, with the exception of complicity, are inchoate acts, they may be committed and a state may be liable for them, even if no genocide actually occurs. End quote. A quotation from the Gambia's memorial. This position attests and shows the blurring of a number of issues relating to judicial policy, the absence of accumulation for different forms of responsibility on a single respondent, for the same set of facts on the one hand, and the issue of substance relating to the conditions for the application of auxiliary counts of responsibility. Article 3 illustrates, I believe, a well-established approach under criminal law, meaning that a number of people can take part in various capacities and through various behaviors in the commission of an act. For each of these individuals, we will have or would have to establish the specific behavior which contributes to the act. But that doesn't mean that it is not necessary to establish that the act itself was committed. On the contrary, these auxiliary causes for responsibility can only come into play if genocide has been committed. And this is and remains true even for the inchoate acts under paragraphs B to D of Article 3, which are forms of participation to different stages of a sizable and complex criminal enterprise such as genocide. The same holds for any breach of obligation to prevent and punish genocide under Article 1. Since your judgment in the Bosnia case, it is well established, and both parties agree, that there can be no failure to comply with the obligation to prevent or punish a genocide unless it is first established that genocide has in fact been committed. So, seeing as the Gambia has not established that genocide was committed in Rakhine State during the course of the events of 2016 and 17, and that is, it seems to me, the obvious conclusion at this stage, the Gambia cannot invoke the auxiliary responsibility under paragraphs B to E of Article 3, or even the responsibility for failure to prevent and or punish. My presentation this afternoon is therefore fully lacking in purpose. However, I will go ahead with it, for indeed the Gambia is clearly mentioning these auxiliary causes for responsibility not so much as an illustration of a factual or legal reality, but as a hypothetical. Namely, those circumstances in which the court would have found that genocide has been committed, but that the acts would not be attributable to Myanmar. At least that is what the Gambia has said in its written submissions. But legal reasoning as such is more than just a collection of possibilities. Auxiliary counts of responsibility are not responsibility for lack of a better option. If the Gambia mentions these auxiliary causes of responsibility, it is to give the impression that its case theory could be similar to the specific situation before the court in the Bosnia genocide case. In that case, having found that genocide had been committed by the Army of Republika Srpska, VRS, in Srebrenica, the court sought to determine whether the acts committed by VRS in that locality could be attributable to Serbia. Having found that it couldn't, the court then sought to determine whether the responsibility of Serbia could nonetheless be incurred under ancillary counts of responsibility, that is Article 3, exclusively as concerned the genocide committed in Srebrenica. Thus, the court ruled in that respect that, and I quote, a finding by the court that no acts that constitute genocide within the meaning of Article 2 and Article 3, paragraph A of the Convention can be attributed to the respondent will not free the court from the obligation to determine whether the respondent's responsibility may nevertheless have been incurred through the attribution to it of the acts or some of the acts referred to in Article 3, paragraphs B to E. End quote. This comparison, association with the Bosnia genocide, as done by the Gambia, thus obscures a number of key factors in the reasoning of the court. First of all, the prior determination of a genocide. Secondly, the identification of the perpetrators. And thirdly, the question of attribution of the acts to the respondent. And it is only at the end of that whole process, and having answered no to all these questions, that the court went on running its analysis under paragraphs B to E of Article 3. Now, to add to this confusion, after the first round of pleadings by Gambia, you wonder whether these remain invoked subsidiarily where acts of genocide would have been committed by persons whose acts are not attributable to the state. Indeed, in last week's pleadings, the Gambia mentioned Article 3, paragraph B, that is, conspiracy to commit genocide, in a way that was both autonomous and cumulative. Let me quote counsel for the Gambia.
Enter into an agreement to commit genocide. Alongside a finding that Myanmar committed genocide, the Gambia invites the court to hold that it also conspired to do so. Fin de citation. And some...
In other words, this ancillary cause for responsibility may apply even though, under the usual rules of attribution, the acts of the organs are attributable to the state. So basically, the state would have to conspire with itself. Whatever the case may be, these ancillary causes for responsibility under Article 3 are based on specific conditions which, for some, were highlighted by previous judgments of the court. Admittedly, other aspects, many indeed, still have to be specified. But your jurisprudence is such that it enables us to identify some of their main features. Thus, the ancillary responsibility may be incurred if genocide has been committed, even if it isn't attributable to the respondent. Yet, it is not a vicarious responsibility. The applicant must prove that the respondent has taken part in the committing of the genocide according to the specific modalities applying to conspiracy, incitement, attempt, and complicity. Such forms of responsibility rely, therefore, on material conduct that is different from that identified to establish the committing of a genocide. These distinct material conducts must, moreover, be attributable to the respondent according to the articles, the 2001 ILC articles, while the acts of persons committing the genocide haven't been. At least in theory, that is what Gambia agrees to, but in practice, it is not trying to identify the distinct behavior and conduct that would fuel these auxiliary responsibilities, nor is it trying to shed light on the issue of attribution. The behavior for auxiliary responsibility is roughly the same as those that Gambia has adduced to establish that genocide was committed. From a methodological point of view, the Gambia simply refers to conduct which it has previously mentioned under and previously discussed under the committing of genocide. However, the same set of facts from the same individuals cannot serve as a basis for both the main responsibility and ancillary responsibility. That too was confirmed by your court in the Bosnia genocide case. The idea of holding the same state responsible by attributing to it acts of genocide, attempts to commit genocide, and complicity in genocide in relation to the same actions must be rejected as untenable both logically and legally. End quote. When it mentions these auxiliary forms of responsibility, the Gambia must therefore not only substantiate specific material behavior and conduct, but also establish the dolus specialis for the persons to whom these are attributed. There can be no responsibility for conspiracy, incitement, attempt, or complicity in genocide unless both elements are present, namely a specific conduct attributable to the state and the established existence of dolus specialis. And indeed, both parties agree that dolus specialis is an absolute prerequisite for these forms of auxiliary responsibility. In practice, the Gambia is not trying to establish dolus specialis for the circumstances in which it is invoking auxiliary responsibility. It is simply referring to the dolus specialis supposedly established under responsibility for the committing of the genocide. And as concerns attribution, it is almost impossible to discuss as everything is so hazy. Both the identification of the genocide committed and the organs that would have committed to conspiracy, incitement, attempt or complicity in genocide. And lacking these, I will only look at the gaps and inconsistencies of the Gambian position as outlined in their written submissions and in court on Thursday.
Pour ce qui est de la responsabilité
Concerning the responsibility of the state for conspiracy to commit genocide, the Gambia considers that, and here I quote last week's pleadings, the Gambia considers that
is ultimately committed, and if genocide is committed, that does not displace the existence of the prior conspiracy to do so. Fin de citation.
End quote. Leaving aside the disagreement on the autonomous character of this counter-responsibility, one wonders what are the material acts referred to by the Gambia which might amount to conspiracy. The Gambia simply states that conspiracy can, and I quote, be inferred from the highly coordinated nature of the clearance operations, end quote. We do not know whether the coordination of military operations amounts to the material behavior referred to or the proof of dolus specialis. In its reply, it puts forward, and I quote, discrimination against the Rohingya, concerted hate speech, and the highly coordinated character of the clearance operations by which the Tatmadaw armed civilians and encouraged them to destroy the Rohingya group. End quote. I note that the very same factors were raised by the Gambia regarding actus reus and dolus specialis when it was trying to establish that genocide had been committed. But these behaviors, if they were to be established, quod non, do not come under the concept of conspiracy in accordance with Article 3, letter B of the Convention. Even according to the definition of international criminal law on which the Gambia is relying, and without insisting once again here on the differences that there might be between those two branches of the law, conspiracy requires a formal or tacit agreement between clearly identified protagonists who have a specific purpose, in the present case, committing genocide. The Gambia did not even attempt to establish that military coordination, discrimination, or hate speech came under the concept of conspiracy. It does not suffice to add the adjective concerted or coordinated to establish that there has been conspiracy. The Gambia did not prove either that this allegedly concerted behavior was aimed at committing genocide according to the meaning of Article 2 of the Convention. Finally, since we do not know who the protagonists of the alleged conspiracy are, it is simply impossible to look into their genocidal intent. On that matter, however, we notice that the Gambia's position is inconsistent. Whereas it ventures in its memorial to identify senior commanders of Myanmar's army by name, in its reply it refers simply in vague terms to Myanmar's highest state organs, and I quote, without specifying further. Last Thursday, Ms. Jones was just as evasive, referring to senior commanders of Myanmar's armed forces and government, end quote, referring to the conclusions of the FFM for 6 of them, whom I mentioned this morning. It is surely not up to Myanmar to guess who the alleged protagonists of such an unidentified and unsubstantiated conspiracy are. Concerning the direct and public incitement to commit genocide, the positions of the parties are in stark disagreement. I will not be coming back to the cross-cutting arguments I presented at the beginning of my presentation. However, I do note that the disagreement on this aspect of the autonomy of this count of responsibility goes beyond the disagreement of the contentious between the parties. The IRC and the ICTR, for example, have different points of view. The IRC considers that genocide needs to have been committed for incitement to have taken place, whereas the ICTR considers that incitement is punishable even if it has not given rise to acts of genocide. That is one more example of a difference between the implementation of state responsibility under the Convention and the implementation of individual criminal responsibility under the statutes of international criminal courts and tribunals. But I do not believe that the court is called upon to make a decision on this difference. It's enough for it to establish that the other conditions for the existence of incitement are not established. Firstly, the specific behavior referred to must constitute incitement to commit genocide. What are these specific behaviors in the current case? The Gambia makes constant reference to the hate speech that it believes it has detected in the declarations of some high-ranking officers or of some privates, as well as the declarations of public figures holding no governmental position whatsoever. But this approach cannot establish incitement to genocide. Indeed, there's a difference in nature between direct and public incitement to commit genocide and hate speech. Direct incitement implies that the utterances at issue contain a direct call that is unambiguous to commit the acts referred to in Article 2 of the Convention. It takes more than a simple, vague or indirect suggestion. The judgment of the Rwanda Tribunal Mikolin judgment that our colleagues across the aisle are referring to draws a clear distinction between what could amount to hate speech and that speech which could amount to incitement to genocide. The tribunal therefore excluded inflammatory speech destined to encourage anger or fuel ethnic hate, retaining only those where calls for murder were explicit, often side by side with the direct expression of genocidal intent. And I will quote a few, even though they can be shocking. Let the Inyenzi realize that if they make a small mistake, they will be exterminated. If they make the mistake of attacking again, there will be none of them left in Rwanda. All the Tutsis and cowardly Hutus will be exterminated. Exterminating the Tutsis from the surface of the earth to make them disappear for good. The reason we will exterminate them is that they belong to one ethnic group. I hope we continue exterminating them at the same pace. This is an example of the type of speech that the tribunal considered to be incitement to genocide. The Gambia makes no effort to show that the hate speech it alleges Myanmar's military leaders engaged in meets the requirement of the jurisprudence. On the one hand, contentious speech itself is often not identified precisely. In its written pleadings, the Gambia makes general references to Chapter 7 of its memorial and Chapter 6 entitled Hate Speech. Within this section, it does not cite and analyze the speech of the authorities in Myanmar, but instead those of the New York Times, Facebook, and the IIMM. Ms. Jones just barely tried to be more specific in her pleadings, referring to a 2017 speech by General Hleing and a video of an unidentified member of the military, without confronting their content to the jurisprudence raised. And as my colleague Stefan Talman showed this morning, none of these examples can be seen as a call and direct encouragement to hatred, and even less so as a call to commit genocide. Thus, the Gambia has not provided precise and incontrovertible evidence that the authorities produced such speech. It has provided even less proof of dolus specialis of those presumed instigators, because it simply broadly fails to identify the authors of the contentious speech. Gambia also mixes the speeches and Facebook posts of private individuals and those it describes without proof to the Tatmadaw. And concerning the speech by private individuals, especially some Buddhist monks, without even needing to establish whether they materially amount to the incitement to commit genocide, one can only note that they cannot be ascribed to Myanmar. Then, the Gambia alleges a failure to prevent and punish in this regard, willfully ignoring the sanctions enacted against them by the Myanmar judicial authorities. That's for incitement to genocide. Now I come to the other letters of Article 3. Attempted genocide and complicity in genocide. Even though the Gambia did not mention it in the hearings, it nevertheless maintains its allegations concerning the attempt to commit genocide. The Gambia's case is a perfect example of circular reasoning. It amounts to saying that since genocide has taken place, then necessarily there has also been an attempt to commit genocide. Of course, the Gambia adds that it relies on letter D of Article 3 only in case the acts amounting to actus reus were, and I quote, somehow incomplete or insufficiently established. Genocide would therefore be incomplete, or its proof would not have been provided. In the interest of time, my answer will be just as expeditious. I would point out that, well, firstly, that the Gambia has not proved that genocide has been committed. Secondly, it has not identified the actus reus that might be incomplete or insufficiently established. Thirdly, it has not established the existence of dolus specialis. Thus, the allegation of an attempt to commit genocide is baseless. The Gambia is rather laconic in formulating its accusation of complicity in genocide. One paragraph in the memorial, another in the reply, and nothing in the oral pleadings, and therefore I will not dwell on it myself. The accusation is based on the same hypothetical scenario. A genocide allegedly has been committed, but cannot be attributed to Myanmar. Instead, it is attributed to unknown or unidentified forces. Since such a scenario is substantiated neither in fact or in law, this allegation can be thrown out without further analysis. I can say the same for the obligation to prevent genocide. One paragraph in the memorial, one paragraph in the reply, one paragraph in the oral submissions, all concerning a hypothetical legal situation to tick all the imaginable boxes of the counts of responsibility. In its written pleadings, the Gambia confirmed the subsidiary character of this count of responsibility, which was based on a scenario whereby a genocide would have been committed by unidentified perpetrators. In its oral pleadings, its approach is rather that of cumulative responsibility, and I quote,
Genocide, it obviously failed to prevent genocide. Don't act.
take it from them. But since the scenario is substantiated neither in fact or in the law, this allegation can also be thrown out without further analysis.
Mesdames et
Members of the Court, this brings me to the purported breach of Article 5 of the Convention on the ground that Myanmar allegedly failed to adopt the legislative measures necessary to enforce the provisions of this instrument. With this count of responsibility, the Gambia is asking the Court to rule on the conventionality of Myanmar's domestic law. This claim goes beyond the nature of your judicial function, it seems to me, as it would require the Court to delve into the ways in which domestic law applies international conventions, a matter known to come under the constitutional autonomy of states. And in fact, Article 5 of the Convention provides for this specifically because it says, pursuant to the respective constitutions. There is no precedent to this claim made by the Gambia in the Court's case law. At most, the Court has had to rule in a very specific situation on the lawfulness of the adoption of specific legislation in the light of the state's international obligations. And I would like to refer you to one of the Nicol case, the judgment of 2022, alleged breaches of sovereign law. But the Court has never ruled on the lawfulness of failing to adopt such legislation at domestic level. This interference in the area of constitutional autonomy is emphasised by the very content of the Gambian position. Indeed, it relies on a particular interpretation of Article 5, which postulates that states are under an obligation to create in their domestic law a specific criminal offence by literally transposing the terms of the Convention and without regard to the legal and cultural differences between the states parties. Now, according to its very terms, Article 5 requires states parties to take the necessary legislative measures to ensure the application of the provisions of the present Convention. As Myanmar has shown in its written pleadings, this deliberate formulation gives states a broad margin of appreciation in determining what is necessary in order to reach the aims pursued. It follows that a state may comply with the obligations incumbent on it under Article 5 on the basis of its ordinary domestic law in criminal matters, such as legislation punishing murder, assault and rape. As Myanmar has demonstrated in its written observations, no less than 57 states consider that they may rely on their ordinary legislation in criminal matters, and the Gambia itself is among that number. Are they all ipso facto in breach of Article 5? Absent a response, our opponents are ignoring the question. Finally, and for the sake of completeness, I would like to add that in 2021, Myanmar introduced in its domestic legal order a specific crime of genocide by making purpose-built changes to the Criminal Code and the Code of Criminal Procedure. This should have rendered this claim ineffective once and for all, had the Gambia not once again taken on its role of critiquing the conventionality of Myanmar's criminal law by finding fault in detail with certain aspects of the legislation adopted in 2021. This criticism points to a poor understanding of the law, which may happen if one is not well versed in Myanmar's domestic law. These mistakes have been highlighted in Myanmar's rejoinder. I have all the less reason to dwell on it that claim can be dismissed on the grounds of the margin of appreciation of the state. Mr. President, I now come to the last count of responsibility, the alleged breach of the Order on Provisional Measures. There again, the arguments of the Gambia are hazy and circular, in disregard of the rigorous demonstration required for such serious accusations. In your order of the 23rd of January 2020, you indicated 4 provisional measures, as the Gambia reluctantly agreed that Myanmar had fulfilled the obligation to report back every 6 months. Only the first 3 measures are disputed. And you can see them on the screen as a reminder, but I will not read them extensively, but summarize them. The first measure provides an obligation upon Myanmar to prevent the commission of acts of genocide, including by persons whose conduct is not attributable to Myanmar. The second measure imposes a duty on Myanmar to see to it that its military, as well as any irregular armed units which may be directed or supported by it, do not commit any acts of genocide. The third measure, the third provisional measure, concerns the preservation of evidence. I will not dwell on this as I discussed it this morning. I would like to focus my argument on the alleged breaches of the first 2 measures, and in particular the alleged deficiencies in the position of Gambia, which make any analysis by the court of these claims irrelevant. The claims of Gambia, as they were formulated in the written submissions, are strikingly unspecific concerning the scope of the measures orders, also with regard to the alleged facts and with regard to the legal qualification of these facts. With regard to the scope of the measures ordered, let me remind you of a number of obvious points. The ratione temporis certainty. Only the earlier acts, only the subsequent acts after the order of the 23rd of January 2020 are relevant. Any earlier acts come under alleged acts of commission of genocide and other forms of responsibility. But the Gambia makes no distinction between earlier acts and subsequent acts. Thus, a good part of its section in the reply on the alleged breach of provisional measures claims that some of the actions confirm the genocidal intention alleged to have driven Myanmar during the operations of 2016 and 2017. Secondly, the ratione materio certainty. The measures ordered do not prejudge the merits in the case, and determining the extent of the actus reus naturally is a matter for the merits, and without prejudice to the facts, and without prejudice to the fact that Myanmar challenges the alleged facts. It would take some qualification effort also to demonstrate that dangerous movements of population, difficulties in accessing humanitarian aid and healthcare during the COVID-19 pandemic and during and after the Matcha cyclone could be included in the actus reus. The Gambia postulates this, but fails to demonstrate it in any way. In the same vein, a great deal of the Gambia's submissions on the reports produced by Myanmar refer, without any demonstration, to alleged discriminatory measures and hate speech, or the failure to repatriate the people in the camps in Bangladesh, facts which unquestionably are not covered by Article 2 of the Convention. And finally, the ratione personae certainty. The first 2 measures only apply to the acts committed in relation to the members of the Rohingya group in Myanmar's territory. The possible acts located outside the territory of Myanmar or affecting people others than those intended in the order are therefore outside the scope of the order, but the Gambia's observations make no distinction on this point either. With regard to the alleged facts, which might amount to the actus reus of the responsibility for breach of the provisional measures, Myanmar and the court are expected to guess what those are, as they have not been specifically identified by the Gambia. Our opponents, in one paragraph only of their reply, refer to murders, arbitrary detention, trafficking in girls, imposing on the Rohingya group unsustainable conditions of living, compelling thousands of them to forced displacement. But the conduct itself is not specifically identified, as the Gambia merely refers back to its written observations on Myanmar's reports, it being up to the respondent and to the court to sort out which conduct is relevant. I doubt that, generally speaking, referring back to submissions compatible with the reports is in line with the principle of legal certainty and the good administration of justice, which requires a specific identification of the parties' claims. It is manifest that in the instant case, this does not allow the respondent or the court to know which specific facts might come under the first or under the second provisional measure. Let me just take one example at random. In order to substantiate its allegations of murders and killings of the members of the Rohingya group and causing serious bodily or mental harm to the members of the group, the Gambia, in the footnote on page 1211 of its reply, refers, amongst other things, to written observations on Myanmar's 6th implementation report, dated 23rd of November, in particular paragraphs 4, 6 and 13. That date is actually that of Myanmar's report, so it is appropriate to begin by correcting that material mistake. The 3 relevant paragraphs of the Gambia's observations on the 6th report can be found in tab 4.2 of your files. Let me assess them briefly. Paragraph 4 refers back not to any specific conduct on the part of Myanmar, but to a resolution of the Human Rights Council which contains that body's findings. This paragraph also refers back to an oral presentation by the United Nations High Commissioner for Human Rights, a presentation which jumbles together mentions of the confrontation between the military and the Arakan army, the fact that the Rohingya and Kaman minorities remain vulnerable, and to the absence of rights for the Rohingya. There is no reference to any specific facts and behaviours after 2020. Only the last paragraph, quoted, paragraph 13, concerns facts which are more or less identifiable. There is a reference to killings, 13, whose ethnic group is unknown, just like the circumstances are unknown, or 20 presumed dead because their boat was overturned. Then there are arrests and convictions for breaches of travel restrictions. To what extent do these actions, assuming they are established, fall within the first or the second provisional measure? To whom may they be attributable? It's impossible to say. Finally, these acts could only be deemed established in defiance of the most basic evidentiary rules. For this example in particular, it turns out that the Gambia refers only to media articles which are not corroborated by other sources. My colleagues have amply described the unsurmountable weaknesses of the Gambia's case when it comes to evidence. These same weaknesses are ubiquitous in the Gambia's written submissions on provisional measures. And the rejoinder of Myanmar provides numerous examples of this, but I will not dwell on them any further. During his oral presentation last Thursday, Mr. Suleiman sought to rectify the situation and to prove more specific in qualifying the measures attributed to Myanmar. With regard to alleged murders, he gave the example of alleged deaths during the inter-ethnic clashes, of collateral victims of the confrontation between the military and the Arakan insurgents, and to the recruitment of Bengalis by the military. With regard to alleged breaches under Article 2 of the Convention, he once again referred to discriminatory policies and difficulties in accessing food aid and healthcare. By way of evidence to prove his allegations, he added a footnote with a plethora of references to UN bodies, reports, media articles, and Facebook posts, which were relied on again under Article 56, paragraph 4 of the Rules of Court, which enables the opposite party to refer to an easily accessible publication. This is more than a habit. It's a pattern of conduct, and one wonders exactly what justifies this position on the part of the Gambia. Ladies and gentlemen, members of the court, these combined elements lead to the conclusion that the Gambia has failed to establish a breach of the first or the second provisional measure. This morning I demonstrated that it had not either established its allegations when it comes to the destruction of evidence. This brings a close to my pleadings this afternoon. Thank you for your kind attention, Mr. President. The next counsel for Myanmar is Professor Talmon. After this in this first round of oral argument, to whom I ask you to please give the floor.
Je remercie le professeur Miron pour sa déclaration. I now invite Professor Stefan Talmon to address the court. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court. My task this afternoon is to deal with the remedies claimed by the Gambia for the alleged violations of the Genocide Convention and the Provisional Measures Order of the 23rd of January 2020. I can be brief. There is no question of remedies, because the Gambia has not established by fully conclusive evidence that Myanmar is in breach of any of its obligations under the Convention or the Court's order. However, for the sake of completeness and to add a belt to the braces of Myanmar's case, let me respond to the substance of the Gambia's claim for remedies. I will address the two claims in turn. Let me start with the remedies claimed for the alleged breaches of the Genocide Convention. The Gambia, as a non-injured state, requests a declaration that Myanmar has violated its obligations under the Genocide Convention and an order that it shall immediately cease any ongoing violation of the Convention. In addition, it requests the Court to order Myanmar to provide assurances and guarantees of non-repetition and declare that it must make reparation in the interest of the alleged victims of genocide, including a long list of specific acts of restitution, as well as compensation and additional means of satisfaction. Mr. President, members of the Court, when dealing with remedies, three questions must be distinguished. First, whether the Court has jurisdiction to entertain a particular remedy. Second, whether there is a legal basis for the remedy claimed. Third, whether the factual and legal requirements of the legal basis are met. I will deal with these three questions in turn. Let me start with the first question, whether the court has jurisdiction. The court's jurisdiction must be established for each individual remedy claimed. Myanmar submits that the court does not have jurisdiction to entertain a claim by a non-injured state like the Gambia for reparation in the interest of alleged victims of genocide. As the court found in the Bosnia case, its jurisdiction is based on Article 9 of the Genocide Convention, and it can therefore only rule within the limits imposed by that instrument. Article 9 provides that the court may decide disputes relating to the responsibility of a state for genocide. The court's jurisdiction with regard to remedies thus depends on what is meant by the term responsibility of a state for genocide. The term responsibility of a state must be interpreted in light of the rules of general international law on responsibility of states for internationally wrongful acts. These general rules on state responsibility do not provide for reparation to individual victims of violations of international law, but for reparation to their states. The term reparation is understood as reparation for the injury caused. Under the general rules of state responsibility, only the state is injured, either itself or through its nationals. The International Law Commission made it clear that reparation to individuals is not part of the general rules on state responsibility when it wrote in its commentaries on the Articles on State Responsibility that Part 2 of the Articles on the content of the international responsibility of a state, which includes the provisions on reparation for injury, I quote, does not apply to obligations of reparation to the extent that these arise towards or are invoked by a state or entity other than a state, end of quote. The court's jurisdiction under Article 9 with regard to reparation is thus limited to interstate responsibility. This result is confirmed by the drafting history of the Genocide Convention. The term responsibility of a state for genocide was not to include responsibility of a state in cases of genocide committed in a state by its own government against sections of its own population. The question of reparation in such a case was to be administered by the United Nations and dealt with in a separate article entitled Reparations to Victims of Genocide. The article, however, was not included due to the strong opposition of states. The Gambia now claims that this state-centered approach to reparation may have been the law in 1948, and that this was no longer the case today. According to the Gambia, the law has evolved. However, it does not provide any evidence for such evolution outside particular treaty regimes. The Gambia's view is also disproved by the court's jurisprudence. In its recent advisory opinion on climate change, the court held, the court considers that whether or not individuals have any entitlement to invoke the responsibility of states is dependent on the relevant primary obligations of states. The Court notes in this regard that certain treaties enable actors other than states, such as individuals or private actors, to bring claims against states on the international plane. Thus, whether individuals are entitled to invoke a state's responsibility for failure to comply with international obligations depends not on the general rules on state responsibility, but on the specific treaties that create obligations governing the relationship between the states and individuals concerned. This clearly shows that the rules of general international law on state responsibility do not include the invocation of responsibility by individuals. Such a right must be provided for in the treaty that creates the obligations that allegedly have been violated. As I said before, there is no such right in the Genocide Convention. The Gambia has no response to this argument other than to assert that the question of jurisdiction has already been decided by the Court in the preliminary objections judgment, and that this decision is res judicata. The Gambia is mistaken when it asserts that a res judicata determination of jurisdiction encompasses jurisdiction over the requested remedies. In the Bosnia case, the Court held that a finding that the Court has jurisdiction does not necessarily prevent subsequent examination of any jurisdictional issues later arising that have not been resolved with the force of res judicata. In that case, the Court distinguished between a finding on the existence of jurisdiction and a finding on the extent of jurisdiction. A finding that the Court had jurisdiction did not preclude a later decision on the extent of that jurisdiction. The question of what kind of remedies the Court may entertain under Article 9 of the Genocide Convention concerns the extent of its jurisdiction. This question was not addressed, let alone decided, in the Court's preliminary objections judgment. The question has thus not been resolved with the force of res judicata. It is admitted that in light of the meaning of the term responsibility of a state for genocide in Article 9, the Court should decide now that its jurisdiction does not extend to claims for reparation in the interest of alleged victims of genocide, because the alleged victims themselves do not have a right to claim reparation under the Genocide Convention. Let me move to the second requirement, that there must be a legal basis for any remedy claimed. Any claim in law, including a claim for a remedy, requires a causa petendi, une cause de la demande, or a ground of claim. The requirement of a legal basis for a remedy has nothing to do with the question of standing. The Gambia's argument of standing is irrelevant for the question of a legal basis and is reminiscent of a quixotic tilt at windmills. The preliminary objections judgment neither addressed nor decided the question of whether there is a legal basis for the remedies claimed by the Gambia. That question was therefore not decided with the force of res judicata in the preliminary objections judgment as claimed by the Gambia. The court would have to decide this question now if it found a violation of the Genocide Convention and that it had jurisdiction to entertain a claim for reparation in the interest of the alleged victims of genocide. Myanmar submits that there is no legal basis for two of the Gambia's claimed remedies. The claim for reparation in the interest of the alleged victims of genocide, and the claim for assurances and guarantees of non-repetition. Let me start with a claim for reparation in the interest of the alleged victims of genocide. Such a claim cannot be based on the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. The basic principles and guidelines are not legally binding and do not create any legal obligation under international law to make reparation directly to the alleged victims of genocide. Even less so do they establish a right on the part of non-injured states to claim reparation in the interest of the alleged victims. I would refer the Court to Myanmar's detailed submissions on this point in Chapter 15 of its counter-memorial. The Gambia relies for its reparation claim also on Article 48, Paragraph 2b of the ILC's Articles on State Responsibility, according to which non-injured states may claim from the responsible state performance of the obligation of reparation in the interest of the beneficiaries of obligations erga omnes partes. However, this provision is not reflective of customary international law, as shown in detail in Myanmar's counter-memorial. If the Gambia wants to rely on Article 48, Paragraph 2b, it must prove its customary international law status. It has not done so. There is no constant and uniform state practice, let alone opinio juris, for a right to claim reparation in the interest of the beneficiaries of obligations erga omnes partes. Claims by 3 states in ongoing litigation before the court are hardly capable of establishing a rule of customary international law, especially if such claims are opposed by the respondent states in the proceedings in question. The Gambia asserted in its reply that no proof of the customary international law status of Article 48, Paragraph 2b is necessary because it was a logical, if not indispensable, consequence of the standing of non-injured states to invoke the responsibility of states for breaches of erga omnes partes obligations. The existence of a right under general international law cannot be based on flawed logical deductions. That a non-injured state may invoke responsibility for erga omnes partes violations does not automatically equate to a right to claim reparation in the interest of the beneficiaries of the obligations breached. As the court held in its preliminary objections judgment, I quote, "Any state party to the Genocide Convention may invoke the responsibility of another state party with a view to determining the alleged failure to comply with its obligations erga omnes partes under the Convention, and to bringing that failure to an end." End of quote. There was no mention of bringing a claim for reparation, despite such a claim having been expressly raised in the Gambia's application instituting proceedings. Contrary to the Gambia's assertion, no support for a right to claim reparation in the interest of the beneficiaries of the obligation breached can be derived from the Court's Wall advisory opinion, where it was held that, I quote, "Israel has the obligation to make reparation for damages caused to all the national or legal persons concerned." The Court did not address, let alone decide, the question of whether a non-injured state had a right to claim reparation in the interests of the Palestinians. An obligation to make reparation on the part of a responsible state does not automatically equate to a right of every other state to claim that reparation. The Gambia now claims that the question has been settled by the Court's recent climate change advisory opinion. In that opinion, the Court mentioned almost in passing that a non-injured state may make a claim for the performance of the obligation of reparation in the interest of the beneficiaries of the obligation breached. However, the Court did not refer to Article 48, paragraph 2b of the Articles on State Responsibility and did not elaborate any further. On the contrary, in the operative paragraph of the opinion, the Court does not mention reparation to beneficiaries, but only full reparation to injured states. It is also of interest to note that although the question before the Court concerned the legal consequences with respect to peoples and individuals, only 3 out of 91 states and international organizations referred in their written submissions either to Article 48, paragraph 2b of the Articles, or to a right to claim reparation in the interest of the beneficiaries of the obligation breached. If such a right was indeed part of customary international law, one would have expected more states to refer to such a right. Let me now turn to the second of the Gambia's remedy claims, for which there is no basis in international law: the claim for assurances and guarantees of non-repetition. The Gambia asserts that it can bring a claim for assurances and guarantees of non-repetition as per Article 48, paragraph 2a of the ILC Articles on State Responsibility. Again, it does not provide any evidence that this provision reflects customary international law. This is not surprising, because everything points to the opposite. Again, I may direct you to Myanmar's counter-memorial. The Court itself, when addressing the invocation of responsibility for an alleged breach of obligations erga omnes partes by a non-injured state, has referred only to declaratory relief and says to assurances and guarantees of non-repetition. A general statement in passing in the Court's recent advisory opinion on climate change does not change that. Mr. President, members of the Court, I will now address the third and last requirement of any remedy claim, namely that the legal and factual requirements of the legal basis of the claim must be met. Even if a legal basis for the two claims at issue could be found in Article 48, paragraph 2a and b of the ILC articles, it is Myanmar's submission that the requirements of these provisions are not met. Let me start again with the claim for reparation in the interest of the alleged victims of genocide. For this claim, the Gambia relies on Article 48, paragraph 2b of the Articles on State Responsibility. By requiring that any reparation claim must be made in accordance with the preceding articles, the provision makes it clear that a non-injured state can claim reparation in the interest of the beneficiaries of the obligations breached only if the beneficiaries themselves can do so. The beneficiaries in the present case would be individuals. According to the court, the invocation of responsibility by individuals, including claims for reparation, do not depend on the general rules on state responsibility, but on the specific treaty that creates the obligations governing the relationship between the state and individuals. In the present case, the Genocide Convention. The Gambia does not show, let alone prove, that the victims of the alleged genocide as beneficiaries of obligations under the Genocide Convention have a right under that convention to claim reparation from Myanmar. The existence of a primary right not to be exposed to genocide does not automatically mean that there exists a corresponding secondary convention right to reparation on the part of the victims of genocide, especially a right against their own state. As Myanmar has shown in its written pleadings, such a right was deliberately excluded from the convention. The Gambia has no response to this argument, but instead claimed in its reply that it demands reparation for the victims based on its own standing as a beneficiary. Mr. President, members of the court, the Gambia has to make up its mind what it wants to be: a non-injured state claiming reparation in the interests of the beneficiaries, or a beneficiary itself. Under Article 48, paragraph 2b, one beneficiary cannot claim reparation in the interest of another beneficiary. Article 48, paragraph 2b also requires that the non-injured state must claim reparation in the interest of the beneficiaries of the obligation breached. The Gambia has not shown, let alone proven, that it is acting in the interests of the alleged victims of genocide and what exactly their interest is. In particular, the Gambia has not specified who the alleged victims are. All Bengali Muslims, including those living peacefully in Myanmar, those who have been displaced, or only those who became victims of alleged genocidal acts. The form and quantum of reparation, however, cannot be decided without this information. The Gambia has also not explained how it has established the interest of the alleged victims. As there are different forms of reparation, the alleged victims may prefer compensation over restitution. Considering also that Bengali Muslims resident in Myanmar would, as taxpayers, indirectly be paying for their own compensation. so they may be content with declaratory relief. In addition, the interest of the alleged victims in national reconciliation may be influencing their choice of the form of reparation. There is no evidence at all that what the Gambia is claiming is actually in the interest of the alleged victims, or that it has tried to ascertain the interests of the alleged victims of genocide in the first place. Let me now move on to the claim for assurances and guarantees of non-repetition. The Gambia bases this claim on Article 48, paragraph 2A of the Articles on State Responsibility. Again, the requirements of this provision are not met. Article 48, paragraph 2A must be read together with Article 30 of the ILC Articles on State Responsibility. According to that provision, a responsible state must offer assurances and guarantees of non-repetition only if circumstances so require. These words indicate the rather exceptional character of the measures. The Gambia has not established that there are any special circumstances in the present case that would require assurances and guarantees of non-repetition. The Gambia's entire argument on special circumstances turns on the character of the obligations allegedly breached, the seriousness of the breach, and the risk of repetition. All these criteria are linked to the fact that what is at issue are obligations under the Genocide Convention. The fact that the obligations allegedly breached are those under the Convention, however, does not automatically give rise to special circumstances, as is shown in the Bosnia case, where the court, despite violations of the Genocide Convention, found that guarantees of non-repetition would not be appropriate. The same is true for the alleged non-compliance with the obligation under a provisional measures order. Again, in the Bosnia case, the court held that non-compliance with the provisional measures order to take all measures within the state's power to prevent the commission of genocidal acts did not require a guarantee of non-repetition. Special circumstances thus require more than alleged violations of obligations under the Genocide Convention or a provisional measures order. And they definitely cannot be based on mere accusations of bad faith, or the curious claim you heard last week that the presumption of good faith must be set aside, while at the same time no presumption of bad faith against Myanmar is to be established. Mr. President, there is another reason why the Gambia's claim does not meet the requirements of Article 48, paragraph 2A. Assurances and guarantees of non-repetition must be appropriate. The Gambia's claimed assurances and guarantees are neither appropriate nor are they in accordance with international law. Dr. Staker has already addressed this point last Friday. Let me focus on two of the most startling guarantees requested. The Gambia asked the court to order Myanmar, I quote, to provide full and equal citizenship to all members of the Rohingya group, and to ensure effective civilian control of military and security forces. Such an order would go well beyond what is required to avoid repetition of any alleged breach of obligations under the Genocide Convention, and would impose obligations on Myanmar which have no other basis in international law. It needs reminding that under the Convention, individuals have a right to be protected from acts of genocide and related prohibited acts identified in Article 3. The Convention is not a vehicle for expanding individual or group rights. The requested order would also deeply intrude into Myanmar's domain réservé. The Gambia here pursues broader policy objectives and wants to transform Myanmar by altering the composition of its citizenship and its governance structure. Is it exactly for the reason to prevent such abusive or excessive claims as made by Gambia in the present case that the International Law Commission required that guarantees must be appropriate and required by the circumstances? Both requirements are not fulfilled. Mr. President, members of the Court, I now turn to the remedies claimed for alleged breaches of the Court's Provisional Measures Order. The Gambia claims restitution to the fullest extent possible with regard to any violation of paragraphs 86, subparagraphs 1, 2, and 3 of the order that directly caused bodily or mental injury, including death, to members of the Bengali Muslim community, or material injury to their property. Where full reparation by restitution is not possible, it claims compensation or any additional forms of reparation. This claim cannot succeed for the following reasons. First, the Gambia cannot have more remedies with regard to violations of a provisional measures order than it would have with regard to violations of the rights that are to be protected by that order. Contrary to the Gambia's assertion, the obligations created by an order are not distinct and autonomous, but are closely linked to the rights at issue in the main proceedings. As the Court observed in the Bosnia case, for the purposes of a reparation, non-compliance with the provisional measures ordered is an aspect of or merges with the breaches of the substantive obligations. It would be absurd if a state would be limited in the main proceedings to declaratory relief with regard to genocidal acts, but could claim restitution and compensation if such acts were later committed in breach of a provisional measures order. As the Gambia is limited to declaratory relief in the main proceedings, it cannot claim restitution and compensation with regard to alleged breaches of the provisional measures order. Second, the Gambia does not provide a single example of an alleged breach of the provisional measures order which has directly resulted in bodily or mental injury to a specific person or material injury to property after the 23rd of January 2020. The Gambia rather seeks an abstract and general declaration by the Court that Myanmar must make restitution or pay compensation for any damage caused without specifying that damage, in the hope to extract from Myanmar maximum amounts of money in subsequent negotiations. The Court's task, however, is not to make abstract statements of law, but to settle concrete disputes. Third, one of the requirements for the indication of provisional measures is the risk of irreparable prejudice to the rights in question in the main proceedings. Here, the right to be protected from killings and other acts of genocide, as well as related prohibited acts identified in Article 3 of the Convention. The concepts of irreparable harm and restitution are, however, mutually exclusive. It is for that reason alone that restitution as a form of reparation is excluded in cases of alleged breaches of provisional measures orders. Breaches of a provisional measures order could, at best, give rise to compensation. The court has never ordered compensation for a breach of a provisional measures order because it has considered satisfaction by way of a declaration of breach to be the adequate form of reparation. Let me conclude. Even if the Gambia were to establish a violation of the Genocide Convention or the Provisional Measures Order, the remedies available to it would be limited to a declaration of breach and an order to cease any ongoing violation. The request for any other remedies should be dismissed as being without any legal basis. I thank the Court for its careful attention. Mr. President, this ends Myanmar's first round of presentation. Thank you.
I thank Professor Talmon. Your statement brings to an end the first round of oral argument on Myanmar. At this stage, Court will put questions to the parties, but before doing so, the Court will observe a break of 50 minutes. The sitting is suspended.